In this video, we will go through the various legal and non-legal responses when dealing with world order issues. Before we begin, it is important to understand the variety of measures or responses that exist. There are different responses to world order. Central to the responses is needing to manage issues of state sovereignty arising from the principle of the nation-state. World order is maintained using the following legal and non-legal measures, all operating under the constraints of nation-state sovereignty. The principle of state sovereignty is the greatest strength and weakness of international law. The implications of state sovereignty are that a nation is its own highest legal authority. All nations are equal under the law. All nations have a right to govern and manage their own domestic affairs. No country may invade or pierce the territorial integrity of another nation, and no nation may impose its values or laws upon another. A state is defined under the Montevideo Convention of 1934 and is central to an understanding of the equality between states and the threshold for self-determination to successfully lead a statehood. State sovereignty can assist in the implementation of world order, but can also act as an impediment to it. There are very specific circumstances under international law when the question of sovereignty may be challenged. If there are extremely grave breaches of human rights, as evidenced by genocide, then the international community may be prepared to set aside sovereignty in order to protect people from harm. We will now look at the following legal measures for resolving conflict and working towards world order. These include the United Nations, international instruments, international courts and tribunals, intergovernmental organisations, and responses by the Australian Federal Government. The United Nations has three main decision-making bodies: the General Assembly with 193 members, the Security Council with 5 permanent members, and the ICJ, which is the International Court of Justice, the judicial arm of the United Nations. The UN, through Chapter 7 resolutions under the UN Charter, allows the Security Council to intervene in states when there are threats to the peace, breaches of the peace, or acts of aggression. Peacekeeping operations, PKOs, are a form of legal intervention that can be authorized by the UN Security Council. Nations create international instruments such as statements, declarations, and treaties. In international law, non-binding statements and declarations are soft law, whereas treaties which can be ratified by the nation-state are considered hard law. International customary law is a very strong form of law, as it is based on consensus and the idea that nations abide by the law because they believe that the practices are appropriate and further accept that breaches should attract a sanction. The Geneva Conventions and international maritime law are examples of customary international law. However, state sovereignty can be an impediment to international instruments, as nation-states can opt not to follow international treaties and declarations. Another legal response to world order issues comes from international courts and tribunals. One of the major international courts is the UN Court, which is known as the International Court of Justice. 66 out of 193 member nations have accepted the jurisdiction of the ICJ. Another major independent court is the International Criminal Court. 121 countries have ratified the Rome Statute accepting the jurisdiction of the ICC. However, USA, Israel, Russia, and China are notable exemptions. There are also a number of other regional courts, such as the European Court of Justice, the European Court of Human Rights, the Inter-American Court, and the African Court of Human and People's Rights. Apart from courts, there are non-permanent international tribunals called ad hoc tribunals. These tribunals are constituted for the special purpose of hearing issues arising from regional disputes. Such issues include genocide, war crimes, and crimes against humanity. Examples of ad hoc tribunals include the following: the International Criminal Tribunal of Yugoslavia, the International Criminal Tribunal of Rwanda, and the Extraordinary Chambers in the Courts of Cambodia. Another legal response to world order issues is from intergovernmental organizations. Intergovernmental organizations are alliances of nations that align on the basis of common political, military, and/or economic interest. Examples of intergovernmental organizations include the North Atlantic Treaty Organization, known as NATO, the European Union, known as the EU, the Organization of American States, the African Union, the Council of Europe, and the Organization for Security and Cooperation in Europe. The final legal response we will look at is from the Australian Federal Government. There are two levels at which compliance with international laws, norms, standards, and expectations are relevant to Australia, that is through internal and external compliance. At an external level, Australia can be an active participant on UN committees, and it can advocate for and support UN resolutions. It can also sign without reservation UN instruments, thus demonstrating a commitment to UN processes and agreements. Australia can also uphold world order agreements through bilateral and multilateral treaties. As part of Australia's commitment to international law and legal processes, it is expected that the nation will uphold international standards and expectations. One such expectation is that as an economically advanced nation, Australia will assist other nations through its commitment to foreign aid. Australia can also demonstrate a commitment to international law through shaping its laws consistent with international standards and expectations. The federal government, under Section 51, subsection 29 of the Constitution, has the power over external affairs. In practical terms, this means that compliance with international treaties falls within the jurisdiction of federal government. When drafting national legislation, the Commonwealth Government can refer to international treaty law and can draft legislation which is consistent with the principles espoused in the international instrument. For example, Australia's ratification of the Convention for the Elimination of Discrimination Against Women was used to help draft the Sex Discrimination Act of 1984. However, all sovereign states can choose the level to which they wish to comply with international law. In this example, which is specific to women, Australia's Sex Discrimination Act makes specific reference to women only in parts and is gender neutral in other parts. In this way, a nation can adapt a law to suit its purposes. In Australia, the United Nations Association of Australia is active in assessing and commenting on Australia's commitment to and compliance with international laws and standards. We will now consider a number of non-legal responses, which include non-government organizations, the media, and political negotiation, persuasion, and the use of force. Non-government organizations are specialist interest-based groups that are independent of government and seek to raise awareness of and redress particular issues. Some examples of NGOs include Human Rights Watch, Amnesty International, Médecins Sans Frontières, and Reporters Without Borders. NGOs have become very powerful lobby groups that can gather information, provide assistance, and use the media to great effect in order to draw attention to problems of world order or inconsistencies between states and international law. A crucial aspect of NGOs is that they remain free from government and particular political influence. This aspect makes NGOs non-aligned, and therefore they can carry out their work without generally being considered politically biased. Without being allied with any particular nation-state or ideology, the independence of non-government organizations ensures that state sovereignty will not be under threat. The International Committee of the Red Cross is one of the most important and largest of NGOs. This is a particularly important NGO because of its early roots and relationship to the United Nations. The Red Cross began initially in 1863 as the International Committee for Relief of the Wounded. The early work of this organization led to the development of the subsequent Geneva Conventions. The movement itself grew and is now the International Committee of the Red Cross that has UN sanction to provide medical aid and supplies to war-torn areas. The ICRC is independent of government and is primarily focused on upholding, creating, and developing international humanitarian law. Another important non-government organisation is Amnesty International, founded in 1961 by British lawyer Peter Benenson. Amnesty International is a global movement of more than 3 million supporters, members, and activists who campaign to end grave abuses of human rights. Amnesty International is independent of any government, political ideology, economic interest, or religion, and is funded mainly by membership and public donations. Another non-legal response to world order issues is from the media. The media has two primary roles with respect to world order. The first, informing the public about world order issues such as conflicts and human rights issues. And the second, investigating and raising awareness about human rights issues and world order matters. The media can enable the widespread dissemination of information on human rights abuses globally and thus place pressure on governments to uphold or negotiate world order agreements. However, the media can also hinder world order by being seen as a threat to sovereignty and an invasion of state privacy. Thus, the media may be controlled by the state, censored by the state, or refused permission to operate. A further complication is that there is also the possibility that the more powerful media outlets may have undue influence on world opinion. The final non-legal response to world order issues to be considered is political negotiation, persuasion, and the use of force. Many world order issues and conflicts can be resolved through effective diplomacy. Diplomacy, or government-to-government negotiations, involve a combination of dialogue and communication, political negotiation, and persuasion. Political negotiation will involve attempting to resolve conflict through communication, which may involve mediation and conciliation before it escalates to the point of armed conflict. Persuasion may be initiated at a government-to-government level with direct negotiation or at a lower diplomatic level. Such actions may include overt or covert threats of economic, sporting, or other sanctions such as the withdrawal of foreign aid. When diplomacy fails, force can be used in solving disputes. However, it can only be used legally, in self-defense, or if proper authority is given by the UN Security Council. To summarize, there is a range of legal and non-legal responses to world order. Legal responses, for example, include the United Nations and intergovernmental organizations, whereas non-legal responses include non-government organizations and the media. If you enjoyed this video or found it useful, please consider liking and subscribing, and thank you for watching.